Hey, folks, my guest today is attorney Travis Hollifield. He's an employment law attorney right in Winter Park. And Travis, I want to ask you this question. Some employment law claims require that you first file some kind of charge before you pursue your employer in court. And so when you say file a charge, you mean with some kind of government entity?
Yes, that's correct. Tom, in most discrimination claims, and I'm talking about discrimination in the workplace on the basis of gender, which is my firm's focus, but other protected characteristics as well, such as race, religion, age, disability. There's a requirement that before you go to court, you have to file a charge of discrimination with an appropriate government agency. Now, in Florida, we have several choices depending on where you live. Certainly, throughout Florida, you have the opportunity to file a charge either with the EEOC, which is the Equal Employment Opportunity Commission, or the Florida Commission on Human Relations. We also call that the FCHR, which is an agency in Tallahassee. Those two entities have a work-sharing agreement, so whether you file your charge with the federal or the state agency, depending on those entities' workloads, one or the other will investigate the charge.
And what is the purpose of having to file that charge first before you go to court? What's the government agency going to do for you?
Well, the idea is that the agency assigns an investigator to the claim. They'll take the charge of discrimination that is submitted. If it's through my office, it would have been submitted by me and my client. They will forward that to the employer, give the opportunity to the employer to file a response that we don't get to see, at least not initially during the investigation. And then the investigator may do some follow-up investigation to try and determine whether or not there's cause to believe that a violation of the statutes have occurred. And then they will either make a finding that cause is found or they were unable to conclude that a violation of the statute occurred, and then send it back to the parties where litigation usually begins.
And so if is going to civil court and suing their employer for damages, does that require first that the government found that there is cause for discrimination?
Absolutely not. That's kind of the interesting rub about the government agency investigation, is that it does not matter. Certainly from the federal standpoint, it does not matter whether or not there is cause to believe the statute was violated or not. There will be what's known as a right to sue letter that would be issued to the plaintiff or to the complainant and his or her attorney, and then that person can still bring a claim regardless of the findings of the government agency investigation.
And when you're in civil court and you're suing the employer, is the government findings admissible evidence in that case?
Well, that's kind of a hot topic right now in employment law, because there's a case that came out of the 11th Circuit, which is an appellate court in Atlanta that oversees all federal courts in Florida, Georgia, and Alabama, that actually permitted those findings to go to the jury. In other words, allowed the jury to see that the EEOC had investigated and had found cause to believe that a violation had occurred. I don't know that I have much confidence that that would happen on all occasions, but that is a leading case right now that's come out in the last couple of years that has the folks in my area of law talking quite a bit.
And do you have any statistics on EEOC about how often they find that there is cause versus no cause?
Statistically speaking, the EEOC does not find cause as often as they find that they are unable to conclude. It's interesting. It's not cause or no cause. It's either they find cause or they are unable to conclude that a violation of the statute occurred. So it doesn't have quite the negative weight that you might assess to somebody that says, no, I don't find any cause here.
Well, then let's assume this. Let's assume that you're an employee. You have filed a discrimination cause charge with the EEOC. You
Yes.
don't have an attorney yet. The EEOC comes back and says, yes, there is cause. Will that finding in and of itself give the employee some kind of relief without an attorney or legal action?
Absolutely not. All that does is that it'll come in the form of what's known as a right to sue letter. And so you'd get this piece of paper in the mail from the EEOC finding cause to believe that a violation of the statute occurred, and then giving that party or that person 90 days 90 days only, within which to file a lawsuit. If you don't file the lawsuit within 90 days, then you lose all of your rights, at least under federal law.
And then say you're in court, you're suing the employer, there is cause for sexual discrimination. How do you measure damages in that situation, or is it more about getting them the promotion that they should have gotten in the first place?
It can be both. The latter part talking about reinstatement, that's considered equitable relief. Legal relief would be relief in the form of money damages. And in sexual harassment cases, as in most discrimination cases, there's basically two types of damages that a successful plaintiff would be entitled to. One is known as economic damages, which would basically be lost pay, lost back pay, lost benefits of employment that can be reduced to a cash value. And then you have the more subjective component, which is emotional distress damages.
Very good. Hey, everybody, my guest today is Attorney Travis Hollifield. He's an employment law attorney who focuses on women's rights. His office is right here in Winter Park, Florida. We're taking your legal questions at 407-297-9696. My name is Tom Olsen. The name of the show is Olsen on Law. You're listening to WDBO.